Good day, ladies and gentlemen, and welcome to the Whittier Trust Company Actionable Ideas conference call. All lines have been placed on a listen-only mode, and the floor will be open for questions at any time during the webcast. On the left-hand side of your screen, you may type in. At this time, it is my pleasure to turn the floor over to your host, David Dahl. Sir, the floor is yours.
Thank you. Good morning, and thank you for joining us on Whittier's webinar for actionable ideas for family succession planning and choosing the right trustee. As we all know, it's been a challenging few weeks. The world is changing, and it's impacting not only our health, but our families and our wealth. At Whittier, we have a clear mission, and it's to take care of our clients and employees. I can't be more proud of our team. We've been in constant contact with our clients. We have preserved wealth for them in this volatile period. Whittier's multifamily office and holistic approach to wealth management is bringing stability, reliability, and confidence to our clients. Several weeks ago, we held a webinar where we discussed our outlook on the economy and the financial markets. 2 weeks ago, we discussed opportunities to transfer wealth to your children, your grandchildren, and intergenerationally. And last week, we discussed real estate and how Whittier is one of the few trust companies that actively purchases, manages, and oversees a broad real estate portfolio. But today, Tom Frank is going to talk about the most important decision you can make, and that's choosing the right trustee. I don't think anything is more critical than choosing a trustee that can serve you and your family. The trustee will be responsible for the investment decisions that are made, fulfilling your desires and wishes, working with your children, grandchildren, and beneficiaries, interpreting the language of the trust, adhering to state and federal laws. But most importantly, the trustee is responsible for relationships, making sure that future generations understand the values and desires of you, the matriarch and the patriarch. The trustee is responsible for teaching the future beneficiaries how to be good stewards of wealth and not just the beneficiaries of wealth. Today, many of us consider naming a friend or a family member, a trusted advisor, as our future trustee. Someone we know and believe that they know our spouses and children. Someone that we are familiar with. But everyone has their challenges. Someone close to us, close to our age, most likely will be in the same position we are as we age and slow down. Putting a family member in charge will always cause divisiveness between family members. Not only must you focus on the relationship you want to foster between the trustee and your children, but you must focus on the trustee's skills. Do they have the knowledge to fulfill their duties? To walk us through all of this is Tom Frank, Executive Vice President and manager of our Northern California office. At the end of his comments, Tom will take questions. Thank you for attending, and Tom, I turn the floor to you.
Thank you, David. Good morning. A few weeks ago, my colleague Victoria Kahn discussed several estate planning opportunities presented by the recent downturns in asset valuations caused by the global COVID-19 shutdown. Today, we want to pivot a little and talk about a topic that is more personal and somewhat less technical, and that is, as David mentioned, who should be the trustee for my family after I'm gone? In my 30-plus years of working with families and multi-generational wealth transfers, this question has been one of the most difficult for clients to answer, second perhaps only to making the choice of who would be the guardian for minor children. Before we dive in, I'd like to just level set a little bit to talk about what a trust is. When we're talking about trust, it's important to distinguish between a living or revocable trust, which is used in states like California as a will substitute, and what I'll refer to as a classic irrevocable trust. The legal practice of estate planning varies from state to state, and in many states, the mainstay of the estate plan is the will. In these states, like New York, for example, where I started my career, estates routinely go through the probate process. Trusts, if there are any, result from the will as part of that estate settlement process. In California, however, the practice is different. The probate process is viewed as expensive, time-consuming, and very public. So the legal practice here has been to use a will substitute in the form of a living or revocable trust. Just to make things a little more interesting, California is a community property state, so the practice is to have spouses typically create joint living trusts. This is not a concept that's found in common law states, and so it's important to remember these distinctions and keep them in mind, particularly for clients who may have started out their lives on the East Coast or in the middle of the country where there's not a lot of community property states and then moved in to the West Coast. So with that as a background, let's talk a little bit about why somebody might use a trust. So again, as Victoria mentioned a few weeks ago, certain types of trusts allow donors to leverage transfer tax exclusions in estate planning. There are certain split interest trusts that allow folks to benefit both family and charity. You can do that at the beginning of the trust term or the end of the trust term, depending on what you're trying to accomplish. One of my favorite reasons for using a trust is asset protection. Typically, assets held in trust for a beneficiary are clearly delineated as separate property rather than marital or community property. I always call this a stealth prenup. It's very difficult sometimes to get our young adult children to talk about prenuptial agreements with future spouses, but putting money in an irrevocable trust sets that money aside and makes it very clear that it belongs to our children. Assets in an irrevocable trust with something called a spendthrift provision, which is pretty typical, are usually immune from most creditor claims of the beneficiary. So, the classic example is my child or grandchild goes down to the local Ferrari dealer with their trust agreement in hand or with their trust statement in hand and says, I want to buy a Ferrari on credit. And the dealer will not give them credit against that trust. They can't use it as collateral. Very interestingly, we had a situation not too long ago where a beneficiary actually had judgment claims, creditor claims outstanding against her. And we were able to protect her assets because they were held in one of these trusts. The lawyer representing the creditor called me and said, we're going to go to court and get an order demanding that you make payment on these debts. And our response was, find us the judge who will do that. It actually worked quite well. Finally, professional management is a good reason to use a trust. Not all heirs are adept at managing assets. My son is a psychologist, great guy, but he's also friends with people who have great investment ideas for the newest bar or restaurant or, nowadays a new app or, heaven forbid, a movie. So I want to protect him from those friends who might come up with those great investment ideas. Independent trustees can help guide younger and less experienced heirs. And we've done this quite frequently at Whittier Trust, where beneficiaries will come to us and ask for money to start a business, for example. And we will walk them through the steps of building a business plan to see if that's viable. Finally, there are certain people who just like to travel a lot. They may want to be out of the country for 6 months a year and want uninterrupted management of their assets, in which case naming a trustee or a co-trustee over their trust could be very useful. Just so we're all on the same page, let's talk for a moment about what a trust really is. A trust is a legal entity whereby one party, the trustee, holds title to the property for the benefit of another party or parties, the beneficiary or beneficiaries. The person who puts the money into the trust, puts the property into the trust, is known variably as either the grantor, the trustor, or the settlor. All these terms are the same. The person or persons for whom the trust is being established are known as the beneficiaries. They're typically current beneficiaries and future beneficiaries, remainder beneficiaries sometimes. So if I set up a trust for my children with instructions to my trustee to make distributions to them during their lifetimes, and then upon their deaths, whatever's left in the trust passes to my grandchildren in that case would be the remainder beneficiaries. It's an interesting arrangement that goes back hundreds of years in our laws, where the trustee holds legal title to the property, but the beneficiaries are said to have equitable title in the property. So you may be asking, what's the big deal about serving as a trustee? Let's talk a little bit about the duties of the trustee. First and foremost, the trustee has an obligation to safeguard and manage the trust property. That would mean, in the case of, for example, real estate or collectibles, insuring the property against loss. It also means prudently managing the property. We'll talk a little bit more about that later. The trustee must make distributions of property and/or its income to the beneficiaries in accordance with the terms of the trust. Frequently, trusts will be drafted where the beneficiaries are entitled to request distributions of the trust principal for various purposes, and the trustee has to weigh those requests very carefully. Consideration has to be given not only to the needs of the beneficiary who's making that request, but also the parties who are set to receive the assets at the end of the trust term. So in my earlier example where I talked about my children and grandchildren, if my child comes to my trustee and asks for a distribution, the trustee also has to consider what the needs are, what the future needs of my grandchildren might be. Now, trust terms can be written to be very flexible and very specific about those kinds of things. And so, it's a great vehicle for making that, for safeguarding those assets, but it's a big decision when the trustee has to consider those requests. There is a duty of loyalty. The trustee has to administer the trust solely in the interest of the beneficiaries. There's a duty of prudence. And that's an objective standard of care in managing the trust property. And state laws dictate what actions and what investments are prudent. It varies all over the map. And so choice of trust situs, the legal framework under which you want your trust administered, is actually quite important. There's a duty not to commingle the trust property and the trustee's personal property. Now, you might think, okay, that's obvious. That would never happen with my friend who I want to name as my trustee. But suppose I'm in a real estate business and I want to name my trusted longtime real estate partner as my successor trustee. Might she make investments with the trust property that would actually benefit her own personal assets? This also comes up sometimes with surviving spouses, where commingling their personal assets and the assets of the trust actually can happen quite easily. There's a duty of impartiality. So the trustee can't show favoritism between current and future beneficiaries. Again, this can be very common with surviving spouses who may invest the trust funds while they're alive in high income producing but low growth assets, therefore sacrificing future returns for the remainder beneficiaries. We see this fairly frequently. Finally, there's a duty to inform and account to the beneficiaries. Again, state law provides detailed descriptions of these trustee duties and obligations, particularly with respect to investments. I want to spend a moment talking about one of the more important duties, and that is the duty to diversify. I'm just waiting for the slide to load here. One of the common law duties of a trustee is a duty of diversification. And all state laws include some version of the Prudent Investor Act. Trustees need to consider investments in a very broad context. In California, for example, a trustee needs to consider taxes, income needs, economic conditions, and the importance of a particular asset to the family. It's a very long list. Absent some special language or consideration, a trustee has a duty to diversify. How does this work in the context of a trust where the major asset is the ownership in a family business? The trustee doesn't have to be a manager of the business. And in fact, it may be better if they're not a manager of the business, but they should be on the board of directors. Frequently, clients will come to us having made their money in a large concentration of publicly traded stock. Again, under most state laws, there would be a duty for the trustee to diversify that. There may be adverse income tax consequences, capital gains to be realized. And again, so lots of things have to be taken into consideration. The remedy for this is language in the trust agreement directing the trustees either to retain that family business or that closely held stock position notwithstanding any prudent investor statutes to the contrary. An excellent use of directed trust jurisdiction in Nevada, for example, is to handle these concentrated positions. And your Whittier Trust representatives would be happy to talk with you about that. Let's move on and talk more deeply about some of the issues inherent in selecting a trustee. As David mentioned, there's a desire for someone to step into the shoes of the grantor, the matriarch or patriarch, and act as the grantor would if he or she were alive and able to do so. Again, in the family business context, there's a need for family business continuity. If the business is the wealth creator for the family and provides a lot of the income for the family, you want to make sure that your trustee is going to be able to oversee those business functions. It's really, really important to find someone who is going to work well with your family members. Ideally, and we recommend this all the time when people name Whittier Trust as a successor trustee, we'd like to meet the family members. We'd like to meet the spouse and the children and even the grandchildren if that is important to the grantor. At a time of great emotional distress, when a matriarch or patriarch passes away, it's going to be difficult to introduce a brand new player to the family scene, particularly somebody who's in charge of the financial affairs. Finally, there's a desire for a trustee who will be able to provide counsel to current beneficiaries while at the same time protecting the long-term interests of future heirs. And a big question that comes up is, can my chosen successor trustee provide counsel to my children and perhaps even my grandchildren? Let's move on now to talking about some of the challenges with naming a child as a trustee. First, naming a child as the trustee assumes you have one with the interest and the ability to manage or oversee the management of your family's assets. Some families will have this situation, some families won't. Again, in a family business context, it isn't unusual for us to see one or more of the children working with mom and dad in that family business. And so they might be a natural successor, you think, to serve as the trustee when you're gone. However, sibling rivalry, which is really just human nature, is tough to overcome in dealing with siblings, right? And there are times when the best of us revert to our 5-year-old selves around the Christmas tree fighting over toys. And now that's an oversimplification, but it can be very, very challenging for sibling relationships. Even if the siblings get along really well, in-laws, husbands and wives of the siblings, can create tensions. And, the classic example of this is the shared family vacation home, from which stems probably more intra-family litigation than perhaps any other asset. So we all know the story. While mom and dad are alive, everyone gathers at the family compound for vacations every summer. And it's a really special place. They want their children and grandchildren to continue to have that home as a center for family unity. Yet once mom and dad are gone, the kids may live in different places. Their spouses may have different ideas about how much money to spend on upkeep, repairs, security, decorating, visits, all kinds of things. It's clearly natural that as a family gets bigger, some people are going to want to use the property more and some people are going to want to use the property less. Now, thinking about these things ahead of time, there are different agreements and governance schemes that can be put in place that will help manage it, but it's very, very tricky. And then, of course, once you get beyond the second generation, once I get beyond my children, cousins are even more remote from one another and conflicts can easily arise. Finally, I have yet to see, with very few exceptions, where resentment does not arise in a case where one child is asked to look after other children. It places a big burden on the child who's asked to take that on. And the single exception might be in the case where one of the children is disabled and it's natural for a sibling to take care of them. But otherwise, it's really fraught with danger. Okay, so if I've talked you out of naming a child as a trustee, what about just naming your spouse as the successor trustee? And in fact, again, as the practice here in California with joint revocable trusts, it's fairly typical to name the surviving spouse as the successor trustee. But you have to ask, has the spouse been involved in the management of the assets? Is my spouse the parent of my heirs, or is he or she a step parent? Very different situation. There may be both, right? There may be children from a first marriage, from a prior marriage, and children of the marriage. And again, naming that surviving spouse as the sole trustee puts a lot of pressure on them. Is the spouse qualified to manage the family's assets? How likely is it that a surviving spouse will remarry or get into a subsequent relationship? I think that is a fear that clients have shared with me from time to time, that their husband might remarry, and then would the husband as successor trustee cut the kid out of property? And then perhaps even more concerning is what happens if there is questionable capacity. If my wife is my age and I die at an old age, there could be age-related capacity issues. There could also be undue influence from one or more children, a new partner. So I've seen this example where mom lives in San Francisco, son also lives in San Francisco, sees mom all the time, takes care of mom, spends a lot of time with her, dotes on her. And the sister lives in another state and doesn't really know what's going on. And all of a sudden, as mom gets older, she really wants to benefit the child who she deems is really taking care of her. Lots of issues can arise there. And then finally, unfortunately, as people age, sometimes there is the potential for some sort of substance misuse or abuse that would further impair their ability to serve as a trustee. Okay, so you say, well, I've convinced you not to name a child or a spouse as a successor trustee. What about naming a friend or a sibling? Here's where it gets complicated. So knowledge of investments, tax laws, and trust laws are all essential to being a successful trustee. First and foremost, fiduciary or trust taxation is a potential minefield. Let's just talk about the case of California, which will come as no surprise to anyone listening, is quite an onerous locale for a trust. So California says that if a trustee lives in California or is a resident of California, at least part of the trust assets will be subject to California fiduciary income taxation, irrespective of where the beneficiaries live. So, for example, I live in California and my child lives in the state of Washington, a state that has no state income tax. If I name a California, my buddy Jim, who lives next door, as my trustee, that trust is going to have to pay California income tax. If I had selected a trustee that does not live in California, a non-resident trustee, the trust wouldn't have to pay any state income tax at all. And that's a fairly technical and sophisticated issue that someone would need to deal with. Also, trust laws differ from state to state. And so the trustee may not live in the state whose laws govern that trust. And so how can the state trustee, how can my buddy who now lives in Salt Lake City be reasonably expected to know and stay current on California's trust laws? Being a trustee comes with a lot of inherent liability. The trustee has an absolute and enforceable duty to do a good job and be prudent. And doing a mediocre job, even unintentionally, might be cause for a court to impose what's called a surcharge, a financial penalty. Here I have down an ILET example. An ILET is an irrevocable life insurance trust. There are lots of reasons to put life insurance in a trust, but there's a court case going back several years in another state where, in this case, actually it was a trust company, was the trustee of the life insurance trust. And the beneficiaries actually sued the trust company and won. Their premise was that if the trustee had taken the premiums that had gone to pay for the life insurance and instead placed them in their own investment products, the trust would have had more money at the end of the day than it had with life insurance. Now, from a fiduciary perspective, that's a lot of risk to take. And you're not doing, essentially we're not doing our friends any favors by naming them as a trustee. Finally, can your buddy say no to your heirs if they need to say no? Again, the Ferrari example. Is Uncle Bob going to tell my son, no, you can't have the Ferrari? Because, he doesn't want to deal with an argument with my kid. So it's a very difficult job. And for those of you who are listening who have ever had to participate perhaps in a parent's estate settlement, you know that it can be death by 1,000 cuts. We had one situation where, and I won't name the major money center bank, but just to close a checking account took about 8 months. And so imagine multiplying that by every little asset that the client, that the estate may have. Okay, so what about naming an independent trustee? And, naming a neutral third-party professional trustee sounds like the answer, but there are questions that still arise, right? So does that trustee have the expertise to work with both my surviving spouse, my children, and sometimes my grandchildren? So again, at Whittier Trust, we like to meet with our future trust beneficiaries before the trust comes into being and we're called upon to act. And we'll typically staff our teams with professionals from different generations and backgrounds to more closely align with the ages of a client's children and grandchildren. That way, the children and grandchildren are going to be more comfortable going and asking questions of their trustee and getting the right advice. Will my trustee have the ability or the willingness to hold quote unquote difficult assets? David mentioned about real estate and the fact that real estate has always been an important part of Whittier Trust clients' portfolios. Many trustees don't want to own real estate. It's hard to value. It's messy. If you've got an apartment building, for example, in a trust, you have to collect rents, you have to make repairs, you have to manage that. It's much easier and frankly more profitable for many professional fiduciaries, bank fiduciaries, to simply sell those real estate assets and invest in marketable securities. That may or may not be the desire of the grantors. Again, choosing favorable state laws like Nevada that have a lot of flexibility in terms of investments that trustees are allowed to hold might make that easier. Really important to make sure that the trustee has the ability to mentor younger generation family members. And that stewardship training is essential to successful intergenerational wealth transfers. Ultimately, you want some family control over the situation. And so what are some ideas for that? Here are a couple of family governance options. Something called a family council. That's actually what Whittier Trust has. The Whittier family set up Whittier Trust over 30 years ago to be their corporate trustee. The family isn't involved in day-to-day management, but meets with the senior management team on a quarterly basis to review their investments and the business objectives and outcomes. This is an excellent way to engage younger generation family members in the management process and make them feel like they have a seat at the table. Family board members. Some family companies or family entities have board members, and each branch of the family might have a voting seat on whatever that governing body is. Sometimes that can be good, and sometimes it might lead to over-involvement of family members as board members. And it also frequently doesn't address issues of generational or sibling conflict. And we see this when we look at single-family offices who have adopted this sort of structure, where there might be an older generation and a younger generation and conflict in how they want to manage the assets. The younger generation, may want to be very involved in the business, may want to try new things, and the older generation is really just saying, hey, let's just keep this thing going. Let's don't rock the boat, perhaps giving up opportunities for growth. There's a concept called a trust protector that has typically been used more frequently in overseas in foreign trusts, but has become more popular here in the United States. And this is naming an individual. It can be a family member or a trusted advisor or a series of these folks who can monitor the trustee. You give them the power to remove and replace your chosen trustee. And so that way, someone always has the ability to kind of hold the professional trustee's feet to the fire to make sure that they're being responsive and that they're being engaged with the family. There are lots of good ideas there. And then placing the assets in some sort of a family entity, perhaps a limited liability company, an LLC, will allow senior family members to retain control by serving as the managing member. Again, this is a great option for family control, but it does require the presence of a family member who is willing and capable of serving in that role. So let's talk about a few of the actionable ideas. That's the name of this series of webinars that we're giving. First, we would encourage everyone on the call to review the goals and objectives of the estate plan. Where do I want this money to go? Children, grandchildren, to future generations for health and education, welfare? Do I want them to be able to start a business, buy a first home? Do I want any of the money to go to charity? Get some clarity around what the objectives are. Review your successor trustee choices. Do these people have the tax, legal, investment expertise? Can they manage my family's dynamics? Are they younger than I am? My best friend Jim, was best man at my wedding. We were college roommates. I trust him with anything. Jim's my age, right? I still think of him as being 20 years old, but he's not. And he's got his own family and his own business to take care of. And while I would trust him with anything, I'm not sure this is a great role for him. And then review your assets. Can my chosen successor trustee manage my homes, business, marketable securities, the private investments I've made, insurance, and where and how assets are custodied? So there's a lot to unpack here. Hopefully what we've done is impress upon you what an important role this is and how it needs to be carefully considered. Now, I think we can move to questions now. We'll show the disclosure slide to make our lawyers happy. Victoria is going to help me out, and I think you have a couple of questions.
I do. Thank you, Tom. That was incredibly informative, and we do have some questions here from our listeners. So the first one of our listeners has written, isn't hiring a professional or corporate trustee expensive? My estate seems simple, and I have my spouse. Why would I incur those costs?
Yes, this is a common misperception. And the best example I can give is there are 2 client relationships on my desk right now that came as the result of very expensive intra-family litigation, where essentially, in both cases, long-time second spouses were named as the successor trustee, and stepchildren sued. And in one case, the legal fees were over $500,000. In another case, they topped out at about $125,000. And all of those costs, which really, that's just going into lawyers' pockets, could have been avoided by picking a neutral trustee or even a co-trustee. I didn't really talk a lot about that, but that's an option that can also be very helpful. If you want the spouse to remain, surviving spouse to have some control, is naming a co-trustee who is an independent professional.
Okay, great. Thanks, Tom. And along those lines, we have someone has written in, what are some of the benefits and drawbacks to having an individual co-trustee with a corporate trustee like Whittier Trust?
Yeah, so the benefit is that individual trustee who's either going to be a family member or a friend or a trusted advisor can help look after some of the family needs, if you will. And so we've worked very successfully with certain family members and friends who are co-trustee. You know, they've known the beneficiaries their whole lives, and they can give us a lot of background and a lot of good information about what the grantors really would have wanted for their children and grandchildren. There are drawbacks to it as well, potential drawbacks, and that is that typically trustees need to act with unanimity. And so there's the potential for conflict among the trustees. Now, again, in over 3.5 decades of doing this, that's been very rare in my experience, but it could happen. Using a trust-friendly jurisdiction like Nevada allows a grantor to bifurcate some of those responsibilities, make it very clear who's in charge of what. So that might be a good solution, Victoria.
Okay. Thanks, Tom. We have another question here. I'm worried that my children will give their stepfather a hard time after I'm gone. I'd like my husband to be in control of the assets while he's still living, so he's well provided for. That's why I'm naming him as the successor trustee. What's the problem with doing that?
Yeah, as we talked, that's a lot of pressure to put on your surviving spouse, assuming, you know, everyone lives to kind of a ripe old age. That your surviving spouse, your husband may not want to hit your kids looking over his shoulder at every little thing. And then the real question is, does your husband have the expertise to really do this? What do your assets look like? Is it a complicated estate? If there is a trusted financial partner, like a Whittier Trust, already in the picture managing some of the assets, again, perhaps naming them as a co-trustee might be helpful. They can take some of the heat and have some of the harder conversations, perhaps, with your children.
Okay, great. And I think we have time for one more. We have someone that's written in that we have an estate with a lot of real estate. What kind of skill set or requirements should I look for in a trustee?
Yeah, so clearly you want someone as a successor trustee who is knowledgeable and comfortable with the asset class. They don't necessarily need to be hands-on real estate managers, but they should have some familiarity with real estate investing and be comfortable overseeing a management team. So, for example, in many of the cases where Whittier Trust serves as a corporate trustee and assets are real estate, we'll hire property managers to, you know, change the light bulbs and make sure that the rent gets collected and handle capital improvements. But we review those statements that they send us every single month, and we visit the properties on a frequent basis, so we know what's going on. It's really, particularly with real estate or privately held businesses, important to have a trustee who's got some business skill. And the more unique the asset, the more important it is to have someone who's got some experience with that particular asset class.
Okay, great. I think there's a few other questions here. Tom will be following up with those individuals, but I think that concludes the question portion of our webinar.
Great. Thank you, Victoria, and thank you, everyone, for participating.
Thank you. This does conclude today's webinar. We thank you for your participation. You may disconnect your lines at this time and have a wonderful day.